Well, here it is, ladies and gentlemen. We have the memo. We have the memo right here. Hi, I'm Craig, and this is Just Informed Talk. I just want to start by saying thank you to everybody who's subscribed and left comments. It's really incredible. You guys are a really smart, intelligent, dynamic individuals, and I appreciate all the inputs. There's a lot of fascinating things, a lot of fascinating angles, and I'm working on some content based off of some comments that have been basically given to me as crumbs, if you will, to follow. I found some incredibly interesting stuff, and let's just get right into the memo, though. So first, this is the actual memo. It is I got this off of here at what is this? The Washington Examiner has a copy right here in this article. If you guys want to go find that, the article name is House Intelligence Memo Released. What it says. You guys can go look at that for yourself, and then you can download the memo. But here we have an actual copy of it, and the first part here is basically going through the president's authority to release the memo and his authority to be a check and balance to release classified information, to declassify information. So it's funny how this is addressed or copied to Paul Ryan and Adam Schiff. So let's just get into the main meat and bones of it here. This is the actual formerly top secret unclassified now memo dated January 18th, and it was issued declassified by order of the President February 2nd, 2018. So this memorandum provides members an update on significant facts relating to the committee's ongoing investigation to the Department of Justice and Federal Bureau of Investigation and their use of the Foreign Intelligence Surveillance Act during the 2016 presidential election cycle. Our findings, which are detailed below, one, raise concerns with the legitimacy and legality of certain DOJ and FBI interactions with the Foreign Intelligence Surveillance Court, and two, represent a troubling breakdown of legal processes established to protect the American people from abuses related to the FISA process. Investigation update. On October 21st, 2016, DOJ and FBI sought and received a FISA probable cause order, not under Title 7, authorizing electronic surveillance on Carter Page from the Foreign Intelligence Surveillance Court. Page is a U.S. citizen who served as a volunteer advisor of the Trump presidential campaign. Consistent with requirements under FISA, the application had to be first certified by the director or deputy director of the FBI. It then required the approval of the Attorney General, Deputy Attorney General, or the Senate-confirmed Assistant Attorney General for the National Security Division. The FBI and DOJ obtained one initial FISA warrant targeting Carter Page and three FISA renewals from the Foreign Intelligence Surveillance Court. As required by Statute 50, 1805 D, paragraph 1, a FISA order on an American citizen must be renewed by the FISA court every 90 days, and each renewal requires a separate finding of probable cause. Then Director James Comey signed three FISA applications in question on behalf of the FBI, and Deputy Director Andrew McCabe signed one. Then Deputy Assistant Attorney General Sally Yates, then Acting Deputy Attorney General Dana Buente, and Deputy Attorney General Rod Rosenstein each signed one or more FISA applications on behalf of the DOJ. Due to the sensitive nature of foreign intelligence activity, FISA submissions, including renewals before the FISA Intelligence Court, are classified. As such, the public's confidence in the integrity of the FISA process depends on the court's ability to hold the government to the highest standard, particularly as it relates to surveillance of American citizens. However, the Foreign Intelligence Surveillance Court's rigor in protecting the rights of Americans, which is reinforced by 90-day renewals of surveillance orders, is necessarily dependent on the government's production to the court of all material and relevant facts. This should include information potentially favorable to the target of the FISA application that is known by the government. And I'm going to break that down, what that means in a second. That just basically means that if there is evidence, and they're going to get into this, if there's evidence that the person being surveilled is being targeted unfairly, they have to disclose that in the FISA court, and that did not happen. So we'll get into that. And that has to do with the dossier and the Steele dossier and Fusion and the DNC. But it says says, where was I? In the case of Carter Page, the government had at least 4 independent opportunities before the FISA court to accurately provide an accounting of the relevant facts. However, our findings indicate that, as described below, material and relevant information was omitted. The dossier compiled by Christopher Steele, the Steele dossier, on behalf of the Democratic National Party and the Hillary Clinton campaign, formed an essential part of the Carter Page FISA application. Steele was a longtime FBI source who was paid over $160,000 by the DNC and Clinton campaign via the law firm Perkins Coie and research firm Fusion GPS to obtain derogatory information on Donald Trump's ties to Russia, which were fake. Neither the initial application in October 2016 nor any of the renewals disclose or reference the role of the DNC, Clinton campaign, or any party campaign in funding Steele's efforts. Even though the political origins of the Steele dossier were then known to senior DOJ and FBI officials. The initial FISA application notes Steele was working for a named U.S. person, but does not name Fusion GPS and principal Glenn Simpson, who was paid by a U.S. law firm, Perkins Coie, representing the DNC, even though it was known by the DOJ at the time that political actors were involved with the Steele dossier. The application does not mention Steele was ultimately working on behalf of and paid by the DNC and the Clinton campaign, or that the FBI had separately authorized payment to Steele for the same information. So what that kind of saying in a nutshell is that in the FISA court, nothing was disclosed about how they knew that Steele was working for the DNC and the FBI had paid him, and the Clinton campaign and the FBI had paid him separately. So that's misleading at least. The Carter Page FISA application also cited extensively a September 23, 2016 Yahoo News article by Michael Isikoff, which focuses on Page's July 2016 trip to Moscow. The article does not corroborate the Steele dossier because it is derived from information leaked by Steele himself to Yahoo News. The Page FISA application incorrectly assesses that Steele did not directly provide information to Yahoo News. Steele has admitted in British court filings that he met with Yahoo News and several other outlets in September 2016 at the direction of Fusion GPS. Perkins Coie was aware of Steele's initial media contacts because they hosted at least one meeting in Washington, D.C. in 2016 with Steele and Fusion GPS where this matter was discussed. It says, Steele was suspended and then terminated as an FBI source for what? Now make sure you follow the dates here. He was terminated as an FBI source for what the FBI defines as the most serious violations, an unauthorized disclosure to the media of his relationship with the FBI on October 30th, 2016, according to Mother Jones article by David Korn. Steele should have been terminated for his previous undisclosed contacts with Yahoo and other outlets in September, before the Page application was submitted to the FISA court in October. So they knew about everything in in September, and they were still misleading the FISA court in October. So they knew in September, and they were misleading in October. That's an important thing to look at. But Steele improperly concealed from and lied to the FBI about those contacts. Steele's numerous encounters with the media violated the cardinal rule of source handling, maintaining confidentiality, and demonstrated that Steele had become a less than reliable source for the FBI. Before and after Steele was terminated as a source, he maintained contact with DOJ via then Associate Deputy Attorney General Bruce Orr, a senior DOJ official who worked closely with Deputy Attorneys General Yates and later Rosenstein. Shortly after the election, the FBI began interviewing Orr and documenting his communications with Steele. For example, in September 2016, Steele admitted to Orr his feelings against then-candidate Trump when Steele said he, quote, was desperate that Donald Trump not get elected and was passionate about him not being president, unquote. This clear evidence of Steele's bias was recorded by Orr at the time and subsequently in official FBI files, but not reflected in any of the Page FISA applications. So they knew in September and they were going in October and withholding this obvious evidence that would suggest that Steele was biased and that his information was unreliable. Now it says, A, During the same time period, Orr's wife was employed by Fusion GPS to assist in the cultivation of opposition research on Trump. Orr later provided the FBI with all of his wife's opposition research paid for by the DNC and Clinton campaign via Fusion GPS. The Orr's relationship with Steele and Fusion GPS was inexplicably concealed from the FISA court. Well, obviously, there's another thing. The Orr's wife worked for Fusion GPS, so there's obviously a conflict there. It says, according to the head of the FBI's counterintelligence division, Assistant Director Bill Priestap, corroboration of the Steele dossier was in its infancy at the time of the initial Page FISA application. After Steele was terminated, a source validation report conducted by an independent unit within FBI assessed Steele's reporting as only minimally corroborated. Yet in early January 2017, Director Comey briefed President-elect Trump on a summary of the Steele dossier, even though it was, according to his June 2017 testimony, salacious and unverified. Could you imagine that conversation where Comey is sitting down with President Trump and trying to tell him about how they have this reliable dossier that has all this salacious and unverified information? I just couldn't imagine how awkward that conversation was. It says, while the FISA application relied on Steele's past record of credible reporting on other unrelated matters, it ignored or concealed his anti-Trump financial and ideological motivations. Furthermore, Deputy Director McCabe testified before the committee in December 2017 that no surveillance warrant would have been sought from the FISA court without the Steele dossier information. So they used a fake dossier that they knew was fake to continuously renew every 90 days their fake and phony and false collection of wiretaps or whatever on Trump and his associates. And finally, it says, the Page FISA application also mentions information regarding fellow Trump campaign advisor George Papadopoulos, but there is no evidence of any cooperation or conspiracy between Page and Papadopoulos. The Papadopoulos information triggering the opening of an FBI counterintelligence investigation in late July 2016 by FBI agent Peter Strzok was reassigned by the special counsel's office to FBI Human Resources for improper text messages with his mistress, FBI attorney Lisa Page, no known relation to Carter Page, where they both demonstrated a clear bias against Trump and in favor of Clinton, whom Strzok had also investigated. The Strzok-Lisa Page texts also reflect extensive discussions about the investigation, orchestrating leaks to the media, and include a meeting with Deputy Director McCabe to discuss an insurance policy against President Trump's election. So there you have it, folks. That is the dossier. I want to thank everybody for watching. God is with you. God's grace is greater. I want to thank everybody for subscribing. Leave your comments. Good luck. God bless and Godspeed.